Alabama sex offenders may have to provide less information to police. A federal judge just ruled 2 reporting requirements unconstitutional.
Today, the state Supreme Court ruled that requiring sex offenders to be on a registry for life is not constitutional without some sort of review process.
Should sex offenders be required to register for crimes that took place before the registry was created in 1995? The state's highest court says no.
Tonight, a federal judge throwing out Englewood's rules for where sex offenders can live, calling the rules unconstitutional.
Our state's sex offender registry violates the Constitution's cruel and unusual punishment clause for 3 plaintiffs.
A Georgia Supreme Court ruling now makes it unconstitutional for law enforcement to use electronic devices to monitor some predators.
It's their right, according to Judge Weaver, who states in this 19-page ruling that the ordinance not only steps on the state of New Hampshire's laws already in place to govern sex offenders, but also violates their right to equal protection under the law.
And basically, a judge has said that Michigan's law requiring sex offenders to stay back at least 1,000 feet from schools is unconstitutional.
And now that the local law has been deemed unconstitutional, local law enforcement has no choice but to go by what's on the state's books.
Now says this local law is unconstitutional.
Nobody has ever been discharged from it. That is the main argument leading a judge to rule Minnesota's sex offender program as unconstitutional.
So this week, a federal court ruled the sex offender registry was unconstitutional with regard to the 2 sex offenders because
the South Carolina Supreme Court ruled unanimously that the state's lifelong sex offender registry is unconstitutional.
Says part of the state's sex offender law is unconstitutional.
The state Supreme Court says a Kentucky law banning convicted sex offenders from living near daycares, schools, or public playgrounds is unconstitutional. Kristen?
Parts of Michigan's Sex Offender Registration Act, or SORA, ruled unconstitutional.
Several years ago, Springfield City Council passed an ordinance that restricts level 2 and 3 sex offenders from living 500 feet within a school. Now that ordinance is no longer enforceable.
More problems arise with Indiana's sex offender registry. It's now been found unconstitutional. As it says, certain conditions for sex offenders are unconstitutional.
A federal appeals court ruled today an Indiana law that bans registered sex offenders from accessing Facebook and other social networking sites that can be accessed by children is unconstitutional.
Yeah, so the court found that if you have a blanket restriction on all registered sex offenders who are on parole, that's unconstitutional because there's no rational basis for that determination.
Tonight, a federal court says it is unconstitutional for states to ban sex offenders from social media sites.
The judge said these signs violated their constitutional rights because they were a form of forced speech.
State law requires a sex offender's driver's license to feature a sex offender label. A Lafayette public defender argued that is unconstitutional, and a Lafayette judge agreed.
Supreme Court justices ruled the housing restrictions were unconstitutional, saying it was making